Hello and welcome to One on One. I am Cyril Stober. The Equ Court of Justice was established in 1991 as the principal legal organ of the Economic Community of West African States. The court is composed of 5 independent judges appointed by the authority of heads of state and government from member states. Its mandate is to ensure the observance of law and of the principles of equity in the application of the provisions of the legal instruments adopted by the community. Today's program focuses on the functions of the court, its role in upholding the rights of citizens of the member states, and its impact on the community. My guest is the President of the Court, the Honorable Justice Edward Amwako Asante, a former Chief Judge of the High Court of the Western Region of Ghana. Justice Asante is described as a jurist, scholar, and human rights advocate. He is a member of the Commonwealth Judges and Magistrates Association and the World Jurists Association. He has been at the Equ Court of Justice since 2018. Your Lordship, welcome to One on One.
Thank you.
All right. Well, you came on board the Equ Court of Justice in 2018. Before then, you were Chief Judge of the Western Region of Ghana. Take us a little bit back to that period and tell us exactly what that entailed as being Chief Judge of the Western Region.
Thank you very much. The Chief Judge, we call it Supervising High Court Judge of a region, and you are the supervisor of all the judges and of all the courts in the region. In my region, we have 34 courts with 34 judges, and I had my own court to run, and also I did administrative work in terms of discipline, mini transfers, and other matters concerning the judges and the staff of the court. So basically, that's the nature of the work that I used to do as a Chief Judge or Supervising Judge of the region.
All right, and so it was from then on, you were nominated to come to the Equ Court of Justice. But then, as we said in our introduction, the judges of the Equ Court of Justice are appointed by the authority of heads of state and government.
Yes.
But the presidency is elective.
Yes.
And so you came on and right away you were elected as president of the court.
Yes, that's how it was. Actually, after swearing in, we ought to have done the election of the judges in Lomé, where we were sworn in, but we decided to do it at the court when we resumed in August. So in August, when we came, each one had to try and lobby the others to vote for him. We were about 3 people who wanted the position. Eventually, I won the presidency, and I started the presidency in August 2018, as you said, up until now. So 3 terms as a president of the court.
Yeah. Well, Your Lordship, at its establishment, the Equ Court of Justice was interstate. Only states could take matters to the court, but at some point in time that changed. Just give us a background into how that changed and then how it moves to tally with the functions of the Equ Court of Justice as it is today.
Okay, thank you very much. Yes, actually the court became functional in 2001 when the first 7 judges were sworn in Bamako. They realized that up until 2004, just about 4 cases had been filed before the court because the states were not bringing cases, because it was an interstate court. They were not bringing cases against each other and all that. So the 4 were even filed by individuals, and the court had to strike them out because they had no locus or standing to bring the cases. Therefore, lawyers and civil society within our community saw the need to advocate for an enhanced jurisdiction for the court. And therefore, in the year 2005, Council saw reason in what they were arguing about, and therefore enhanced the jurisdiction by giving the court the human rights jurisdiction, such that they could hear cases of violations of human rights that occurred in each of the 15 member states against individuals and some corporate entities. That is how come the court became vibrant and started actually functioning as a proper court within the jurisdiction, and to give people their rights that they deserved in the region.
Right, and that bringing in the jurisdiction in human rights issues with citizens, and that makes it significant, seeing that this is a region where there are serious concerns about the rights of citizens, especially in terms of the states that are most of the times absolute in authority. So how has the Court of Justice been able to fare in this scenario?
Yes, you are right. There's a myriad of human rights violations within all the member states. Some even are political rights violations, preventing people from contesting election when they are legally right to do so. Violations of brutality, property acquisition wrongly, and so many others. But then when they come to the court looks at the law. Primarily, the court applies the African Charter on Human and People's Rights and all other human rights treaties that each of the member states have signed onto. And luckily, they've all signed the Universal Basic Human Rights Instruments, the Anti-Torture Instruments, the Maputo Protocol, and all of them, all the countries have signed onto them. So it's easy for the court to refer to any of them if the violation fell under any of them. So for that reason, the court has been able to have a very wide range of treaties and laws to apply against the member states, who mostly are the defendants or the respondents in the matter, because it is state actors who actually do these violations. Violations by non-state actors do not come to the court because those are not of international nature. It's only cases of international nature, violations of international laws, and those done by state. Because of course, if an individual slaps a friend, that's a violation, but then it cannot come to the Equ Court of Justice because there are local laws and local courts that are well equipped to deal with those matters, and therefore we look at those of international nature and deal with them. And the court has done pretty well in this area. Yes.
And for a layman, I would say, now these member states have their local laws. At what point can matters be taken to the Equ Court of Justice? Was it when all other avenues have been exhausted locally, or at any point in time? Or are there any specific issues which may be addressed by the Equ Court of Justice and which the local courts do not have jurisdiction over? Yes,
thank you very much. That is a very thorny issue. You know, member states have all their laws, all the human rights laws within their constitutions and their laws to apply to cover almost all human rights violations within the states. However, the Equ Court of Justice also had its human rights jurisdiction by law. And the law that set up that human rights jurisdiction for cases to be admitted into the court set out only two exceptions. And the two conditions are, one, that the matter should not be anonymous, and that the matter should not be pending before another international court. And therefore, it didn't say that if the matter, if the parties should exhaust local remedies. That is the very issue, contentious, that's always between us and the state parties when we meet to have judicial dialogues. Generally, under international law, international courts have to hold their hands and wait for matters to go through the whole gamut of trial within the national courts before, if they are still not satisfied, they go to the international courts. However, the Equ Court itself also has a jurisprudence that it is not, doesn't pretend to be an appellate court over the national courts. And therefore, if a matter goes through the gamut of trial in the national court, we will not entertain such an action. And therefore, our jurisprudence is that the party has an election. Once it's a violation by state actors, which squarely falls within the responsibility of the state, the party has an election to commence the matter at the Equ Court of Justice or at the national court. And when he comes to the court and we realize that the same matter has been put before the national court, we hold our hands or we tell him to elect whether he wants to go to the National Court or to the Equ Court of Justice. The matter cannot be heard twice.
Your Lordship, doesn't that make this a very tight and closed scenario? Because as you yourself might well admit, in some of the member states, there are times that political issues have influenced legal issues in the courts, especially matters involving the states.
Yes.
The Equ Court of Justice, you've just said, is not an appellate court over the national courts.
Yes.
So what happens to a citizen, say, whose rights have been violated and cannot get justice through a national court? The matter just ends that way? They cannot bring it before any other, but once it's been dealt with by a national court?
Yes, to a large extent, yes, unfortunately so. Except that in certain few cases, the court, as I told you, the human rights court dealing with violations of human rights. Right to fair hearing, right to be well represented are all human rights.
Yes, sometimes.
And therefore, if a person is denied that right, despite that the matter goes through the Supreme Court, that is also a right that has been violated. If the Supreme Court doesn't permit a person to even call his witnesses or to appear and have his matter tried well by his lawyers, that is a violation. And therefore, that aspect will surely come to the human rights Equ Court.
Right. But then when matters are brought before the Equ Court of Justice and judgment is given, what is the process of enforcement of these judgments, and wherein the state refuses to adhere to it? What happens, since there's no appellate court beyond the Equ Court of Justice? Obviously the community hasn't thought that's necessary, but let's hear your views on that. Yes,
that's also another big issue that we are still grappling with. You know, the judgments of the court are declared within our protocols to be final and enforceable within the member states. Member states by law have to appoint what we call national competent authority within their countries who receive judgments of the courts and enforce them within their jurisdictions. As at now, 11 out of the 15 member states have appointed a competent national authority, and then mostly they are the attorney generals. That is the funny side of it. The attorney general who represents the state before the court has also been appointed as the competent national authority to receive the judgment. Already he is aware of the judgment because he was in court when it was pronounced, and he is also authorized to enforce it. And therefore, that's where the will of the state and self-will comes in. And it's a bit difficult for them to enforce the judgments. That's a very serious issue. Then they are talking about the appellate system. There's no appeal against the court because we don't have any appeal chamber. On our continent, it's not the East African court that has an appellate chamber over the decisions of the first instance court. We've made representations to the powers that be several times that is very necessary for them to test and know whether the judgments are very good or not. But then, citing financial issues, as always, that issue has not been dealt with. However, the law is that the judgment is final and enforceable within their national states. There was a case where one Chudimba had judgment in the court against Ghana. He sent the documents to Ghana to have it enforced in the High Court, and it was rejected and struck out for the fact that Ghana had not domesticated the ECOWAS protocols and all that into its civil procedure processes, and therefore ECOWAS court judgment cannot be enforced within, and therefore all member states apply this. So when the judgment is obtained here, you may be flinging your judgment to go to wherever you need to go, but you cannot go and enforce it within the member states. So it depends on self-will, and that's a big issue for us now.
And doesn't that detract a little bit from the functions of the court if it gives judgments and a member state decides that it has not domesticated the appropriate provisions, and therefore the judgments just go that way?
Yes, because judgments of the court are also deemed to be responsibilities of the states to enforce them. Now, the president of the ECOWAS Commission is the only person who can go to court to have the judgment of the court enforced, and he comes before the ECOWAS court itself for an authority to enforce. If a state, he does that, and if a state doesn't enforce, there are sanctions that are to be applied. The sanctions include excluding them from major positions, major meetings, and all that. But that, in my estimation, has never been taken up. And so all member states, whether they enforce their judgments or not, are still enjoying all the booties and the goodies that all other member states are enjoying. In the Europe, you compare it to the Council of Europe has the powers. You know, they've been given the powers, and naming and shaming, no state even wants its name to be mentioned as not undertaking its obligations. So theirs is a different ballgame, though it also depends on self-will, because there's no serious procedure by which it can be enforced. But they, being a more developed area, Council of Europe has been set, the foreign ministers have been set up, and they ensure that decisions of the European Court are enforced. That's the difference between ours and theirs.
One might want to think that perhaps the Commission would want to take a second look at that provision. But you do have instances right now where certain judgments of the court had not been enforced in some member countries. Now you say 11 of them have set up the machinery, the others haven't?
Yes.
No. What
No
happens
sanctions.
to those who nothing?
No, nothing happens to them. And even those who have set up have not enforced most of the judgments against them. And even some who have not appointed have also enforced some of the judgments. But on the whole, from our statistics, we look at something less than 30% enforcement rate. Yes, though not backed by any serious statistics, but because normally lawyers and parties come to the court, they give feedback on the enforcement of their judge. That's how come the court is able to assess and get to know that about less than 30% are enforced.
Your Lordship, as president of the court, does that, I mean, do you get frustrated by a situation like this?
Obviously, not only the president, all the judges of the court. We have time and again tried to hammer home this point, trying to get the Council of Ministers, the heads of state, to get to know. Last year during the mid-year conference, I made a submission regarding the non-enforcement of the judgments of the court. And well, for the first time, we were happy. Council made a recommendation that we have a meeting with the chief justices in the region, in the sub-region, so that they will see how to help in enforcement of the judgment. So last week there was a meeting, and the council, they responded very well. They've taken on board the reasons, most of the reasons for the non-enforcement of the judgments, and there's going to be another meeting for them to discuss and make recommendations to council. So I'm sure something good may come out of it to make sure that judgments are enforced. Because otherwise, I always ask the question, what's the use of a court if its judgment cannot be enforced? Then the court better not exist.
Now, Your Lordship, let's look at the process of the court sitting. Where does it sit? And since this is a court of justice for the Equ region, where yes, it's headquartered here in Abuja, the Nigerian capital, but how is it sitting? How does it sitting take place?
Yeah, as you said, it's headquartered in Abuja. Therefore, the court mainly sits in Abuja. There's a courtroom, everything. We sit here. But then there's also this external court session which was introduced before we came. And we have done 2 of them. We've sat in Abidjan and we sat in Accra before. Previously, we've sat in about 10 of the member states at various times. So what the court does is that they normally do cases that are in the surrounding countries. They list them and the parties come there for that. But that has been overtaken by events, because now we do Zoom online sitting. Since COVID, we have been able to lay the very good infrastructure for this kind of activity, and therefore, whether we sit in Abuja or anywhere, parties log in, we give them the system, they log in with their lawyers, their witnesses, they're able to have the full trial, very seamless trial, without traveling to Abuja. So parties are saving a ticket for themselves and their lawyers, hotel bills and all that. So that is where we are now. So the sitting is now virtual. 2 days ago and yesterday we sat virtually, all logged in, hearing is clear, everything is done, and judgment is delivered now.
Well, let me look at other aspects of the court and its functions. It has, yes, jurisdiction over human rights matters with individuals and the state. What others? I'm looking at some of the treaties and agreements that have been signed by member states and some that have not been.
Yeah.
put into practice. Does the court have jurisdiction over those as well?
Yeah, the court, as you said, it's virtually a toothless bulldog. We cannot enforce that, ordering states to sign the treaties, no. But then we give advisory opinions. Those ones are sought by, could be the president of the commission or any of the ECOWAS institutions. If there's an issue, a nagging issue regarding any of the treaties and protocols, they refer it to the court. Parliament has referred some twice or thrice to the court for the legal opinion, advisory opinion of the court, which is given, and then they follow them. Also, the court is also a civil public servant court for staff of the entire ECOWAS, the region. We have so many institutions all over, and there are staff there, so obviously there are staff issues which are also determined by the court at a certain stage when they go through certain matters within their institutions that don't get resolved. The court is the last resort. Then also there's the duty for us to act as an arbitration court, but it has not been set out because the arbitration laws have to be set up. We've done everything, prepared and sent to council. It's up to council to pass the law. Then the court can also do arbitration cases. The last function is also referenced by individuals or corporate bodies of their cases to be determined by the court. Parties can enter into a contract on their own once they are community citizens, and they determine that the determining court, in case there's a dispute, should be the ECOWAS court. Once it is agreed between them and a dispute arises, they can refer it to the court, and the court determines those matters. So these are some of the areas the court deals with. Okay.
Sometimes you have challenges with determining actions that are justiciable in the court, because I'm looking at it. For instance, the human rights issues we started with, the rights of the citizens to fair hearing, not to be discriminated against in politics, and either for cases of gender or by virtue of, yes. So, but again, within such, because these things are also captured under the laws of the member states, do you find challenges with what is actually justiciable and what isn't?
Yes, we do, and that's what I said. That's the admissibility clauses. It shouldn't be anonymous, and it shouldn't be pending before another national court. But then the third major one is that the case should be of an international nature. Mm-hmm. That is to say, should be committed by state actors. So if state actors get involved in some of these violations, it could be the government itself, could be the police, the military, and all that, then these are the ways that the court used to determine whether the matter is justiciable before the court or not.
Well, at the establishment of the ECOWAS Court of Justice, they had 7 judges.
Yes.
And that was scaled down. How has that impacted on the work of the court?
The impact is enormous. Though the 5 judges have tried very well, looking at the records, with the 5 judges, we've done far more cases than when they were even 7. But the issue is that it's because the court is now catching up with people. People are now, through sensitization, people are now getting to know the court, and therefore more cases are being filed. Those cases, yearly, they could file 10, 15, up to about 20 cases those days. But now, every year, it's about more than 50. Last year, they filed 69 cases before the court. So that is the aspect. But then what I say devastating impact is that if we had 7, with the number of increases in the cases, would have done more, because we could set 2 panels. We sit in a panel of 3 judges. So now we can set only 1 panel at a time. But if we had 7 judges, we could do 2 panels at a time. So it means with the 5, if one judge is incapable of sitting for some reason, one has traveled and all that, the court may not be sitting because of the number of judges that we have. So with the 7, obviously, it would have been better, far better than the 5 that we have.
Your Lordship, there's a key issue you mentioned here just now, and that's sensitization.
Yeah.
A lot of times, citizens in ECOWAS countries, in this part of the world, are not too keen on taking matters to court for very obvious reasons. The process, It's cumbersome, it is slow, and in many of the countries and member states of the ECOWAS region, going to court is usually not the first choice of many of the citizens, given the level of awareness, the level of the literacy level, and so many other factors. And not many citizens would be aware of things they can actually take to the ECOWAS Court of Justice. So has the court played any key role in sensitization, bringing its functions to the generality of the citizens of the community?
Yes, the court has. Honestly, since we came in 2018, annually we decided to have sensitization missions in 3 countries per year. So we've gone to most of the countries. In Nigeria, we've gone to Lagos and then to Kwara State in Nigeria. Then in other countries, we've gone to Gambia, Sierra Leone, Liberia, all the countries, to do sensitization. And when we do, we meet lawyers, civil society groups are there in their numbers, market women. Almost all the groups are invited. We do per session, we meet them, we go to various places and meet them and let them know about the court, the functions of the court, what the matters they can bring before the court, and all that. So that is one of the reasons since 2018, the number of cases filed before the court has increased tremendously, and the court has also done its best to deliver more judgment in respect of that. So that has caught up very, very well with the people. Yes, and then luckily, you don't pay any legal fees when you are filing the case before the court, because the court is for the community. Therefore, there's no filing fee for anybody. All you need to do is maybe to pay your lawyer. So that is the only aspect where indigent citizens may be found wanting. But then the court has also put in place a legal aid structure. The system, the laws, everything has been established. But then we need authorization and then funding for it. So it's been sent several times to the Council of Ministers, who are the main lawmakers, the primary lawmakers. Once the president of the court is able to put it before them and they agree and accept it and pass it into law, funding may have to be given to it so that the court can also even help fund the indigent citizens. But that is not forthcoming.
Again, because they were going to go right there and say funding for the court and how it can carry out its functions. Because if you take decisions, then at some point it's expected that you'd be able to do something about that. But how has the funding generally been for?
Well, for the court, so far so good. So far so, except that these days, with the exit or the suspension of 4 major member states, so community levy is dwindling. Community levy comes from all the member states, and then it's out of that the budgets of the various institutions are also given, and so things are getting a bit tighter. But
that presents an interesting scenario where some members decide to opt out of the community, and what if there are cases or issues pending involving nationals of a member state that decides to exit? How can that be resolved? Because the basic thing here is to ensure that the rights of citizens are upheld. Now, an issue has started, and in the middle of it, there are challenges about withdrawal or remaining in the community. Can the court deal with that issue? Yes,
the court decided that initially when those 3 countries were suspended, we also suspended matters affecting them. But then upon other consultations and meetings, we had admitted them because we found that the sufferers were the citizens who were suffering, and most of them were the plaintiffs before the court, and therefore we started admitting their cases. However, when the 3 recently withdrew officially, and they sent their documents to the commission, which was passed on to all the ECOWAS institutions, then they themselves, their lawyers appeared before the court and told us they had mandate to inform the court that they were no more part of the community, and therefore they will not be part of any matters before us. So that is the state for the 3 who have decided to withdraw now. They themselves have told the court that they are no more part of the community and they are not accessible to any activities of the court. So we are waiting. And there's a 1-year leverage within which they may finally go or not, and therefore we are still. But since they themselves have come to tell us this and with the documentation, the court has
that does mean that if there are cases involving their citizens at this point, those cases automatically
obviously
stood down.
Yes, yes, that is it.
Your Lordship, we'll continue with this conversation in just a moment. We'll take a short break here. When we return, there'll be more on the Equ Court of Justice. Stay with us on One on One.
NTA Tuesday Live, a network issue-oriented innovation talk show.
Why should we be in a difficult situation financially?
Once upon a time we were rich, but we're not a rich country anymore.
Disaster management is everybody's business.
In all these times, the organization turned to Nigeria.
We would as much want to harness the capacity that is within us so that we see how we can become self-reliant.
1 month ended and you said you are increasing warning strike by 2 months. I mean, you are incubating madness.
Even if these are officials of government who have been told to go and enforce the law and they have gone against the law itself, they must be held accountable.
One on One, Friday, 10:30 p.m. on NTA Network.
Thanks for staying with us, and we're still here with the President of the Equ Court of Justice, Honorable Justice Edward Asante. Your Lordship, let's look at the angle of partnerships between the Equ Court of Justice and other institutions of the region and international bodies. What is the scope thus far?
Well, as a court, as much as possible, we try to be independent and on our own. But then we do judicial dialogue with other courts with like jurisdiction. We have MOUs with the African Court on People Human Rights, and therefore annually, last year we went to Arusha, had discussions, 2 days judicial dialogue. We discussed common issues that affect both courts and find a way forward, because we apply virtually the same laws. So we do that annually. We have had occasion to visit the European Court. They invite us almost every 2 years. We go, we have discussions with their judges. We learn best practices from them. They also learn from us on what to do, how to improve our systems. We visited the International Court of Justice and the International Court of the Criminal Court. We also have had the opportunity to. So we deal with them. Raoul Wallenberg Institute, also in Sweden, sometimes it's a purely human rights institution. Sometimes for refresher courses, they invite us, we have discussions with them and on various and emerging areas of the law. You know, the law is growing, and therefore if there are certain areas like transitional justice and other areas which we may not be very well dealt with here. So we have those kinds of partnership and MOUs with people and institutions, the Red Cross, you know, the humanitarian laws and all that. So we deal with all these people, but not seeking funding from any institution to fund us. No, we are 100% funded by the community through the community levy.
You emerged as the 6th president of the Equ Court of Justice, and before you, the court had been there. In the last 4 years, how have you been able to take the Court of Justice, the Equ Court of Justice, to greater heights from where it was before, initially, and today? What are we looking at as an institution that is abreast of modern trends and, you know, impacting on the community?
Yeah, thank you very much. Generally, we have, under our watch, I think the number of cases, the awareness through sensitization has been very big. As I said, these days, every year, more than over 50 cases are filed before the court. and judgments are delivered. Before we came, the highest number of judgments I had delivered was 30. We came to 38, 41, and last year we delivered 59 judgments within the year. This is the kind of work we are doing in the court. Now, you could also see, we are saying that judgments are not being enforced, but at least they are being respected and people are getting satisfied. Some parties now, in a couple of cases, they come to court just to vindicate their rights and settle certain things straight. They did not even ask for reparation or compensation. That to let the world know that their rights have been violated and then they've gotten justice. There are some such cases before the court. So it is the satisfaction that people get in the court that also make us happy and work more. So generally, I think we have worked hard. The court is now very well recognized. The East African Court, the African Court, when we meet them, they applaud us. They say that our court is indeed a court of the region, of the continent, and that is so.
In your career, Your Lordship, you've been both on the bar and now on the bench, and you have a clear view of issues of the rule of law in West Africa. As you sit back, there are challenges all over the states, and we started off by saying there are huge concerns to deal with the rights of citizens. But beyond that, generally the rule of law is seen as to be very low in this country. What are your thoughts about this?
It is very true. It is very true. But it's all through, I think, power drunkenness of most of the leaders in the community, because it beats one's imagination if your tenure ends and you want to stay on, or there are certain rights, basic rights and basic things that must be given to the community that leaders are preventing them from getting. There are basic things. The constitutions provide them directive principles of state policy. They are all there: right to education, right to fair hearing, right to courts, effective remedies in matters. Because if your state actors brutalize people, they kill people around, journalists and all, and the security system is not able to work and function very well so as to be able to get investigations undertaken and prosecute the perpetrators. That is what brings the impunity. And almost all the governments are looking and watching for these things to happen. So generally, rule of law is very, very, very low. And then politically, that's another aspect. People wanting, giving positions to their people, trampling down other people who are deemed to be opponents and all that, and refusing to hand over, refusing to do the right election. All these have strands of violation of the rule of law in them. And therefore, I agree with you, it's very, very low in our region, and we may have to do something about it.
Sometimes people ask and say, is it the absence of adequate or appropriate laws? Is it the will to enforce such laws? Or is it that many of the laws of the member countries could be seen as either outdated, not in tandem with the realities of the moment? Or is it also, can it also be seen as the fallout of their past, being colonies of other parts of the world? Is it not time these things were shaking off?
The laws, I think they are good. We have good laws on our statute books, but the implementation and enforcement is a problem. Because, the colonial powers, they gave certain laws, we have amended them with time, and most of them are abreast. All the countries have fine constitutions, fine laws to comply with, except that in some cases, particularly in the Francophones, which I may say, where the Constitutional Court has a right to amend their constitution to extend tenure, but you feel that and the 5 Anglophone states, it is not so. When your tenure is up, it is up, and you go, and it's been replicated all over the place where even Liberia recently did a very fantastic one by. So I think the laws are there, except that it is the willpower to enforce them is the issue, and then the people themselves, as I said, power drunkenness by people wanting to be in their comfort zone for a while without allowing others who are due to occupy the positions. So there are a myriad of reasons for this. I don't think it's the loss, it's the human factor itself.
Let's look at another aspect here where being part of the community, citizens ought to be guaranteed free movement, among the countries of goods and persons, but then states also have reasons sometimes to deviate from that. I'm looking at scenarios where a state decides to close its borders and prevent access to nationals from another country, or where one member state decides to bring in certain laws that make it extremely impossible for citizens of other countries who are in that community to function in there. What happens when you come up against situations like this?
Yes. This is the integration we are talking about. It's supposed to be a total integration, freedom of movement, free settlement, free work in all member states. That has been agreed upon by member states at the council level, at authority level. But then, as you said, member states themselves have put certain inhibitive procedures in place. Sometimes when you go somewhere, I enter Nigeria, my passport is stamped, I enter. You enter some country, you need to pay some development levy, $50 or 20 euros before you enter the country. Those are the things that the Commission has to take up. There are laws and regulations regarding all this. Once the community has taken them up, if any such thing happens, the president of the Commission has to go to the ECOWAS court to enforce the laws. But we have not seen any president come to the court to enforce any of these laws. And these are that because politically it is virtually impossible for them to do so, So these are otherwise the law is there to be enforced. If the country doesn't, it is an obligation. If the country doesn't comply with this obligation, regulations are there. They are denied access to major meetings, denied positions in ECOWAS and in international, but they lobby among themselves and get positions in the UN, WIPO. So there are so many international organizations where member states are represented, and through the lobbying of ECOWAS. And therefore, if you do not comply with these obligations, it is up to them to deny you the chance. But they keep on doing this. That's how come some countries are putting on barriers against the free movement, freedom of work, and all that.
Today, as the Equ Court of Justice stands, what would you say are the biggest challenges in its path in executing its mandate and bringing about the achievement of why it was set up in the first place?
The challenges for me, the reduction in the number of judges, very bad, citing financial issues. Justice is expensive everywhere, and therefore 5 judges, one will ask, what does we earn by reducing the judges from 7 to 5? It doesn't have any serious financial impact in the kitty of the community. So the reduction, because we are now able to set up only one panel, is very bad, and it's militating against us. We have done more than we are doing now. Then also the non-enforcement of the judgments of the courts. That is a very big issue, because people are not even enthused anymore to come before the court, because he comes with all the time, everything, and doesn't get judgment before the court. Then what's the use in coming again? So they are very adamant in coming to the court to have their matters vindicated. So that is one thing. And talking about resources, accommodation, I may have to praise the government of Nigeria for this. The court was in a very small, ramshackle building, but then the past 2 years, they've gotten a very good 4-story building for us. So now there's space to work. So the court, I think staff are very happy. Everything is being done very well in an office. And we are even looking up to the building of the main commission office where the court and parliament are, for it to function properly as a court. Though now we are functioning properly, the air of freedom as a court. Yes.
No doubt this has enhanced the work of the court and for carrying out its functions. So, if I might just ask, if you would assess, maybe on a scale of 1 to 10, they always say that justice delayed is justice denied. How long does it, on the average, take to dispose of matters like this? Granted, there are other issues involved in prosecuting or coming to a determination, but one would have a fair idea of, well, if I took my matter before the Equ Court of Justice, would I expect justice to be done to me in 1 year, 2 years? Because we have cases of these violations pending in some national courts for 5, 6, 7 years upwards.
Generally, in the Equ Court, I will put it at an average of 1.5 to 2 years. It depends, you know. We do translation. We work in 3 major languages, in Portuguese, French, and English. And therefore, when document files, and huge one at that, with exhibits are brought, even at the filing stage, the law is that the party himself should have them translated, but they don't have the money. And therefore, we have a language services department with just about 5 or 6 translators who sit down to translate all the process. That one can take over a year. Because it's not only one case that we have. There are so many cases aside that judgment or the judges are also being translated alongside. So sometimes we may even have to resort to freelance translators in these matters. And therefore, that one alone may take a year. But if you are lucky and the case comes and the panel is just an all English panel, like now, 5 of us, for the 5 judges, 3 are English. And therefore, if you get to one language panel, then after closing of the written procedure, that takes about 6 months, the matter could be heard, and within a year, judgment may be delivered. So it depends on the dynamics of particular cases.
You've been at the court since 2018, and we, of course, have talked about the amendment which brought about a reduction in the number of judges. But again, the question of tenure as well, there has also been a change. And initially, from what we read, judges would be at the court for a period of 4 years, right? 5 years. But now we understand that this has been extended. What would you say led to that?
Yeah, the initial was 5 years renewable, and they even staggered, you know. Okay. So 3 of them would be there, and then 2 will come and all that. So all the time there was institutional memory preserved within the court. That's how it was working. But then since the amendment in 2018, that we came, all 5 of us will come 18 and leave in 2022. That was then in 2022, because of the suspension of the 3 member states, they were to allocate position. They were allocated position to bring judges to the court. But because of their suspension, they didn't qualify to bring judges, and therefore they said the 3 of us, 3 big states in ECOWAS, Ghana, Nigeria, and Cote d'Ivoire, who had judges on the court should remain, and that's how come our tenure was extended to remain there until such time that the coup countries will revert to civilian rule and then bring their judges.
Okay, so this was just a happenstance, a matter of circumstance.
Exactly.
And nothing to do with the individual countries that this extension has been taking place. That is. Yeah. But in all of it, again, you have remained as president of the court, and at some point in time, with the risk of not asking you to assess yourself, what would you say Honorable Justice Asante has brought? First, you come straight into the court and you elected its president, and now you've had the full term, and by circumstances, you've had to stay on. What would you say that does to Justice Asante?
Well, initially, because I was lacing my boots to return to my country to go and settle and continue with my work until I retire. But suddenly, this decision was taken, and we are working for the community, and therefore, we have no choice but to stay on. But if today the countries they come back and we are asked to go, we just pack and go and continue our work in our country. So generally, we are working for the community, and we are happy to do that.
You know, they say that with this profession, the older, the more knowledgeable, the wise men who sit on the bench. At the time you came in, you were seen as one of the youngest among those who have been there.
Yes.
And so there was the element of youth and experience combined. Tell us about that and how that reflects in combining both youth, knowledge, and of course the maturity of being on the bench.
Yes, especially with the position as a president. That's it. My colleagues always say. And this is the head that wears the crown. And therefore, I had a lot of positions to occupy. As you said, being the youngest among them, the more senior persons, both on the bench in their countries, they were Supreme Court judges, and then by age. But then we have to manage and navigate our way through. There were staffs who were older and younger, various troublesome and cool, who were supportive and all that. So generally, it all builds up the experience. And I can say that now I think I'm far more experienced and more sober, more humbled by the work, and then more experienced and more poised to do more action when I go back.
If you were to take a step back and look at the Equ Court of Justice in the future, in the next 4 years or more, what position would you like to see it in, and what would you be saying, having been here, I think these are the things that we should do better, and I think these are the things we should maybe do differently, and how you would see this court in another 4 years from now?
In another 4 years, I see a court that is very responsive to the calls of people, because as it is now, people are calling on the court. Many people are coming. Sonko was before the court, the Senegal issue. As soon as matters happen in states, they come to the court. And the court, those cases are given priority and dealt with just to satisfy the exigencies of the situation, so that people know that the court is very responsive. And that is what the court is doing now. Matters that come, we will not leave them to lie on for the matters to be moot. And so I think the responsiveness of the court to the needs of the people is now something that has started, and I hope that it continues with those who will take up from us, so that the court's relevance will be felt more within the community. So basically, that's a court that I'm looking at, that will be able to work harder and improve upon what we have done.
And for the larger community, and for all these challenges, some of them which we have touched on here, be looking to making this court an invaluable institution of the community, of ECOWAS, especially when it comes to the terms of enforcing its judgments. What would you like the Commission, the Council of Ministers, and the Authority of Heads of State to consider as a matter of urgency to further place this court on a proper pedestal?
Yes, I think there are two basic things. The President of the Commission is, once he is notified that these states, the list who have not enforced their judgments, it is his duty to come to the court for the orders. Once it is done, he presents it to authority, and then they may sanction the colleagues who have not done that. But then, more importantly, states must domesticate the laws within their procedural laws, such that if a party gets judgment in this court, he can personally go to the nation and enforce that judgment through their legal system. For instance, international judgment, we've got foreign judgments by other foreign courts. You go to the arbitration court elsewhere and the judgment is delivered. You can enforce it in your country, because by registering it in the system, they certify the authenticity of the judgment. You easily go through the civil procedure, and so why not judgment of our own community court? But it's been brushed aside by member states, citing the fact that they have not domesticated the laws, which is that even neither here nor there, because pacta sunt servanda. If you are part of a treaty, you cede part of your sovereignty, and then you enforce all the treaties that you sign. So there's no gainsaying at all. That's
right.
Yes.
Okay. Honorable Justice Edward Mwaku Asante, President, Equ Court of Justice, it's been interesting talking to you. We thank you for coming on One on One.
Thank you very much for having me.
Right.
Thank you.
Right. And that's our program today. We thank you for watching. Next week, we'll be back with One on One. I am Cyril Stober. Bye for now.